Good afternoon, or good morning to those of us in the West. My name is Jan Christensen Wood, and I'm the Vice President of the Canadian Association of Social Workers. I have the honor of welcoming you all to the 2015 Educational Webcast in celebration of National Social Work Month. The theme for National Social Work Month this year is Social Work Profession of Choice. It was selected by the CASW Federation to communicate the profession's unique scope and significance in meeting the needs of Canadians. Many of you will be aware and may have already submitted your story to the Social Work Profession of Choice promotion at CASW. CASW, with the support of our national liability insurance carrier, Aon, is running this program on National Social Work Month. I encourage you all to check out the stories on the CASW website. These have been submitted by social workers from across Canada. They're truly inspiring and make me proud to call myself a social worker. For today's webcast, we have over 650 people registered connecting from every part of Canada to hear about negligence and documentation for social workers. The sponsor of today's webcast is Aon, the national liability insurance carrier for the Canadian Association of Social Workers. Thanks to their generosity, CASW is able to provide this webcast free of charge. Today, we're extremely fortunate to have Professor Robert Solomon, who is on the Faculty of Law at Western University, where he holds the rank of Distinguished University Professor. He is here to present to us on negligence and documentation for social workers. Professor Solomon has traveled throughout Canada and Australia presenting legal programs in his fields of expertise. One of his major areas of concern has been the increasingly challenging legal environment facing social workers, health practitioners, addiction staff, and youth workers. The first half of the webinar will review basic principles of law governing the social worker's potential civil liability and negligence. The second half of the webinar will begin with a review of the general principles of law governing documentation. As a matter of housekeeping, I would like the audience today to know that the format of the webcast will be an approximately 1-hour presentation by Professor Solomon, followed by a half-hour question and answer period that I will be moderating. During the presentation, you can type in and send your questions at any time, and I will begin to ask them at the end of the presentation. Now, without further delay, it is my distinct pleasure and honor to welcome Professor Robert Solomon.
Thank you very much. Before I begin the task of focusing on the two key issues that we're going to discuss, and I want everyone on the webinar to come away with a good working understanding of the general principles of negligence liability and documentation or record keeping as it pertains to social workers. I want to talk about some preliminary issues. The first is the changing legal environment. For better or for worse, the legal environment in which social workers work is far more challenging than ever before. And there are a number of factors that explain why this is. Canada has become a far more litigious or legalistic society than ever before. All professionals, doctors, nurses, engineers, accountants, are coming under closer legal scrutiny. So it's no surprise to me that social workers are also subject to increasing legal challenge. Also, in our society, we have recognized the rights of young people, old people, those with physical and mental disabilities to make their own treatment, counseling, and care decisions. And social workers will often find themselves trapped between their confidentiality obligations to their patients and the expectations of parents and others who think that they have a right to know. We have also seen a proliferation of complex technical legislation that increasingly governs the practice of social work in various provinces. And finally, these legal changes have been occurring at a time of fiscal restraint, where all professionals are being asked to do more with less. You may not like the fact that you live or you work in a more challenging environment. You can't change the fact, but you can change how you respond to that fact. And having an understanding of these principles will help you identify and avoid legal problems. Now, having said that the environment is more challenging than ever before, it is important to emphasize that Canada is not California North. Our courts don't expect that you're going to understand the law, all of its details. They don't expect that every one of your decisions are going to be correct. Rather, our courts demand two things of you. First, have you acted as a reasonable social worker in all of the circumstances? You don't have to be right, you only have to be reasonable, as judged by what would be expected of your peer. Secondly, has the social worker acted in good faith? And acting in good faith means putting the legitimate needs of the clients first. Now notice I said legitimate needs, because sometimes clients will ask you for things that you cannot provide them with because it's not permissible or lawful to do so. Now, if you look at the court's expectations, namely that did you act reasonably and did you act in good faith, these legal requirements are wholly compatible with your professional and ethical obligations as a social worker. I'm now going to turn and talk a little bit about the sources of legal authority that you have in terms of dealing with your clients. There are two basic sources. The first is the client's consent. The vast majority of circumstances, your relationship with your clients will be predicated on obtaining the client's consent. There are, however, some statutes which give the state and other individuals the right to treat and detain individuals. So the two sources are client consent and statutory authority. The best example of statutory authority would be the mental health legislation in the various provinces and territories, which gives the state the right to apprehend and detain and in some circumstances treat individuals without consent. But for the most part, for what social workers do, your legal authority comes from the client's consent. And one of the keys is obtaining the client's consent at the outset of the relationship, not only in terms of the counseling, but also in terms of the policies that govern record-keeping, confidentiality, and disclosure. It's also important to distinguish between situations in which there is a legal rule or there's legal authority from management policy. In many circumstances, I'm told by various and sundry individuals that the law prohibits or the law requires. And in many of these circumstances, it's not the law that is requiring this particular course of conduct, but rather management policy. I'll give you an example. I often go and give talks in schools in Ontario, and I'll be told that the Education Act prohibits the provision of counseling services to students under the age of 18 without parental consent in writing. Well, that's not in fact true. The Education Act precludes IQ testing without parental consent. Rather, this ban on providing counseling to those under 18 without parental consent is a management policy. And so it's important to distinguish between management policy, which can be changed, and legal authority as dictated by statute, which cannot be changed. I'm now moving to slide 4. We're going to begin talking about negligence and negligence liability. The first thing to understand is that you're not held liable in negligence because the treatment fails, because the patient relapses. You're not a guarantor. You're not an insurer. So it's important to understand what negligence is. Negligence is the failure to meet the standard of care that would be expected of a reasonable social worker in all of the circumstances. So when you think about negligence and negligence liability, think about carelessness. Think about substandard care, because that's what it is. Your obligations in terms of exercising reasonable care extends across the full scope of your professional responsibilities. So that would include not only the counseling that you do and the record keeping and referring. So the obligation in regard to exercising a reasonable standard of care applies across the full spectrum of your professional responsibilities. What is the standard of care that is expected of you? The courts do not know very much about social work, or for that matter, many of the standards that apply to other professionals. In these circumstances, the courts rely on expert evidence from the professionals themselves to determine what is the reasonable in the circumstances. So the standard of care expected of you as a social worker is not some abstract concept imposed by the courts from outside, but rather a standard that is selected by the court as informed by the profession itself. I want to now distinguish or talk about negligence liability for which you are liable and errors in judgment, because you have to distinguish between the two. You're not held liable for errors in judgment. And so what is an error in judgment? An error in judgment is a decision which turns out in hindsight to have been wrong. This is illustrated by the case of Mustafik and Smith. In Mustafik and Smith, a patient was admitted as a voluntary patient to a psychiatric facility in Manitoba. One day, the psychiatrist, a preliminary assessment was that the patient suffered from mild anxiety and depression, and he had not yet formulated a definitive diagnosis. The next day, the patient asked for a day pass to spend time with his two children, and the psychiatrist granted the day pass. The patient was voluntary and could have left in any event. And the patient comes back. The next day, he asks for another day pass, and he's granted a day pass. He goes home, he picks up the two children, and he shoots both of them. One is severely disabled, the other is killed, and the patient commits suicide. The wife sues the psychiatrist and the psychiatric facility in negligence, claiming they were negligent to have granted the patient a day pass. And while the court acknowledged that the decision that the psychiatrist made in hindsight was wrong and had a tragic circumstance, however, the court held that the psychiatrist had met the standard of care. There was no evidence of homicidal or suicidal behavior in the conduct or the record of the patient. The psychiatrist's decision was an error in judgment for which there was no liability. It's also important to distinguish between negligence, for which you can be held liable, and incompetence. When we talk about a negligent decision, we're looking at a specific decision, a specific act. When we talk about incompetence, incompetence is generally defined as an inability to meet the standards of one's profession. So if your college finds you to be incompetent, they may suspend or revoke your license. So what's the difference? The mere fact that one of your decisions fails to meet the standard of care does not mean that you are incompetent. An incompetency refers to an inability to meet the standards of the profession, and so it's important to distinguish between the two. I want to go on. I want to talk now about customary practice in assessing liability. If you, a social worker, can prove that what you do is consistent with customary practice in the social work field, that provides some evidence of reasonableness. If the plaintiff or the client can prove that you breach customary practice, that provides some evidence that you have been negligent. Again, the rules around customary practice reinforce the importance of social workers acting in a manner that is consistent with their profession. I'm now going to turn and talk about when are you going to be held liable in placing and supervising staff. Our courts expect that those in an administrative position, those who are administrators, those who are managers, those who are supervisors, exercise reasonable care in making the decisions, the placement decisions that they do. And this is illustrated by the case of Granger. In Granger, supervising nurse placed an inexperienced nurse, assigned an inexperienced nurse to monitor a woman in labor. The inexperienced nurse failed to detect decreases in the fetal heart rate in sufficient time. And as a result, the child suffered hypoxia before an emergency C-section could be undertaken. The inexperienced nurse acknowledged that she did not have the skills necessary to monitor women in labor, and she was held liable. And what that means is if any professional takes on a task where they know or ought to know they don't have sufficient skills, they can be held liable if something adverse happens. The supervising nurse was held liable in her personal capacity because she knew or ought to have known that the inexperienced nurse did not have the skills that were necessary. And this is important because administrators and supervisors and managers are expected to know the training and capacities of their subordinate staff. And when they place a person in a position, a staff member, they will be held accountable for their decisions. I'm now going to turn to slide number 5. I want to talk about liability for negligent assessment. It's quite clear from the cases that you're not going to be held liable in negligence because the assessment you have undertaken wasn't perfect. You're only going to be held liable for negligent assessment if you ignore some obvious fact or there's no reasonable basis for the conclusion that you have reached. And this is illustrated by the case of Muir. I won't go into all of the details in the Muir case, but basically the plaintiff was admitted to a provincial institution for mental defectives, as it was called back then, without any psychometric testing being done, based on cursory information about emotional problems. The institution ignored one professional who indicated that this young girl's problems were not cognitive, but rather emotional. No psychocognitive testing was done for 2 years. When it was done, it indicated that she had a normal IQ in some ways and a substandard IQ in others, but she did well in school. From time to time, she was admitted at antipsychotic medication, even though there was no evidence or diagnosis that she was psychotic. And when she showed a normal interest in sexual matters, she was referred to the sterilization board, where she was permanently sterilized, even though the sterilization was conducted contrary to the provincial legislation. She eventually was released from the institution, and when she learned that she had been permanently sterilized, she brought a civil suit, and the institution and province were held liable. It's those kinds of circumstances where there's no reasonable factual basis for the assessment or other reasonable information is ignored that liability is going to be imposed for negligent assessment. Liability for negligence in counseling. The simple fact is it is fairly difficult to be held liable in negligence for counseling. And the reason for that is there's such a broad range of acceptable counseling approaches. If social workers are going to be held liable, it's not going to be over the counseling, but probably rather over the record keeping related to the counseling. And this is illustrated by the 2 cases we have up. The first is T and Caskell. In this case, the plaintiff sued her social worker in negligence claiming that counseling sessions had evoked memories of childhood sexual abuse, and that these memories caused the plaintiff to descend into self-destructive behavior, which involved, at least according to the plaintiff, criminal acts, alcoholism, drug abuse, and suicidal depression. And she sued the social worker for her defense fee in her impaired driving case, damages to her car in the impaired driving crash, and loss of employment income due to the criminal record. The court dismissed the plaintiff's claim. And the court stated that the social worker met the standards expected in providing such counseling. She had not forced or pressured the plaintiff to recall these memories. The plaintiff had not exhibited any outward signs of distress, and there appeared to be both a good external and internal support mechanisms in place for the plaintiff. Moreover, the social worker had indicated that there appeared to have been a strong therapeutic alliance with the patient. And so even though the plaintiff was displeased with the counseling and claimed all of these far-fetched losses due to the counseling, the claim was dismissed. The next case is GI and Rush. In this case, the plaintiff disclosed to her social worker that she had been sexually abused by members of her family. The social worker explored with the patient these memories of being sexually abused. The patient confronted her family and went to the police. The police investigated the patient's claim and chose not to bring criminal charges. The family then sued the social worker, claiming that the social worker owed the family a fiduciary duty, that is, a duty to act in utmost good faith in the family's interest, and owed the family a duty of care in negligence, to exercise reasonable care for the interests of the family. And the court was very clear. A social worker owes a fiduciary duty to his or her patient, not the patient's spouse, not the patient's family. And the court said that recognizing a fiduciary duty to someone other than the client would create an intolerable circumstance and prevent the social worker from meeting her paramount legal obligation, and that is to the client. Similarly, the court held that a social worker owes a duty of care in counseling to the patient, not to the patient's spouse, not to the patient's family. And so the message from the court in the Rush case is keep your focus on the patient. And the patient is your client, and the patient is the person to whom you owe professional responsibilities. And it's really important message, particularly in cases in which you're seeing a child and pressure is put on you by the parent of the child, or you're seeing a client and pressure is being put by the patient's employer. You owe a fiduciary duty to the client and the client alone, and you owe a duty of care and negligence to the client and the client alone. The next area in which we're going to discuss is liability and negligence for responding to allegations of abuse. What we have seen is a sharp rise in civil litigation in regard to child abuse in this country. This was an issue that was ignored for years and years by all social institutions. But after the native school scandal, the Mount Cashel scandal, this has become an area of heightened legal concern. So we're going to look at two cases. The first case is CD in Newfoundland. In this case, a foster child had been physically abused by her foster mother for 12 years and sexually abused by the foster mother's brother. She complains to the social worker who is responsible for monitoring the home. The social worker had a close personal relationship with the foster parents. And when the first complaint was made by the foster child, the social worker did nothing. She did not come to the house. She did not investigate the claim. She ignored a credible allegation of abuse. It's quite clear in this day and age that no one can ignore a credible allegation of child abuse, sexual assault, etc. The plaintiff made a second complaint 4 months later, and the director of social work services appointed a second social worker to investigate. But when the first social worker complained, the head of social services called off the second social worker, and the head of the service and the social worker came to visit the home. During that visit, the first social worker browbeat the child into withdrawing the allegation. Even though it was quite clear that this placement was not working out, the child was kept in this foster home for 6 more months, where the abuse continued. Finally, the plaintiff brought a civil suit against the first social worker and the head of the social work agency. The court held the social worker liable in negligence for failing to properly supervise and monitor the placement. The social worker was held liable in negligence for failing to investigate the foster child's allegation of negligence and for her biased intervention into browbeating the child into withdrawing the claim. This is an example of a situation in which the social worker acted in bad faith. The social worker put her relationship with the foster parents ahead of her duty to protect the child. The head of the social services was held liable as well for calling off the second social worker. Again, the head of the social work service put the feelings of the first social worker ahead of her duty to protect the child. The second case is a case called Young and Bella, and I won't go into detail in that case, but that's a case in which a social work school, a professor in a social work school, engaged in conduct that resulted in a student's name being put on the child abuse registry. The social work professor had not confronted the student in regard to that allegation, as recommended by the acting director of the social work program, had not confronted the student in regard to that allegation, as recommended by Child Protection Services. And it was as a result of that failure to undertake those preliminary steps that the professor and the university were held liable in negligence. I'm now going to turn and talk about liability and negligence for making placements. And again, the question is not, is the placement perfect? Not, is the placement ideal? But is this a reasonable placement in the circumstances? Now, when you make a placement, you have 2 obligations. The first obligation is to ensure that the placement does not endanger the client. The second obligation is the obligation to ensure that in making the placement, you do not put the receiving agency at risk. And I'll briefly talk about Hendrick and DeMarsh. In Hendrick and DeMarsh, a probation officer placed a young offender with a family without informing the family of this young person's history of arson. The parents go out, the young offender burns down the townhouse, a civil suit is brought. And the court made it clear that when you make a placement, you have a dual duty. The first is to ensure that the placement doesn't endanger the person being placed. And the second duty is to give the receiving agency or family sufficient information to make an informed choice as to whether or not they wished to, whether or not this person meets the criteria for admission, and whether or not the institution wishes to receive them. I'm now going to turn and talk about liability and negligence for failing to obtain an informed consent. And everyone talks about the duty to obtain an informed consent, but very few people actually understand what is entailed. So there are three basic sets of principles that govern when a consent will be an informed consent. First, the person proposing the treatment must disclose to the client all of the material risks involved in the proposed treatment. This includes not only information on the risks of the proposed treatment, but information putting those risks in its broader context of its reasonable alternatives. Now, a material risk can be a very low probability of a serious consequence, such as a 1 in 500 chance of death or a 1 in 1,000 chance of paralysis. And almost all of the cases deal with these kinds of serious risks. A material risk may also be a higher probability of a more modest risk. So let's say there's a 35% chance of a minor, easily controlled infection consequent on the surgery. Well, that would be a material risk. So all healthcare professionals, counselors, and others have a duty to explain to the patient all material risks of the proposed treatment and to put that proposed treatment in its broader context. There is also an obligation on the part of care providers and counselors to explain non-material risks of particular concern to the client. And the best example of that is, let's say a procedure has a 2% chance of minor residual stiffness in your ankle joint or in my ankle joint. Well, I'm a law professor and I'm 68. That's not a high probability and it's not serious, so it's not going to be a material risk, so it wouldn't have to be disclosed. But if I was a professional hockey player or athlete, then the residual stiffness in the ankle would be a non-material risk which you know or ought to know will be of particular concern to the client. And again, the issue of informed consent is probably of greatest concern in terms of high-risk medical procedures, of less concern in terms of counseling. However, if the counseling involves very sensitive, highly emotional things, if the counselor is a psychiatrist who's prescribing antipsychotic medication or other medication which has very significant side effects, then obviously these issues are would be critically important to them as well. Also, all individuals who are providing counseling and care and treatment have an obligation to answer all of the client's questions openly and honestly. In an era of expanding concern about patient rights, there is no right to withhold or deceive clients. All questions must be answered openly and honestly. I'm now going to turn to slide 7 and documentation. I think this area is subject to a lot of misunderstanding. And people will tell me that, there are forbidden words and there are words that they have to use, etc. In fact, it's very simple. What our courts demand of you is that the record reflect your honest, best view of the circumstances. Basically, the courts demand that you call them as you see them to the best of your ability. And I think the easiest way in this area is to keep your focus on the client. What does the term client record mean? The term client record basically refers to any information that you have about the client's treatment, counseling, or care howsoever recorded. So it doesn't matter if it's handwritten, if it's a computer record, it's an audio tape, it's a videotape. Any information that you have recorded about the client's treatment, counseling, or care is part of the client's record. Some general principles about documentation, and this is probably the most important thing to remember about documentation. The driving force behind record keeping or documentation is not the law. The driving force is the client's need. If you have the record you need to provide ongoing quality counseling or care, you have the record you need for legal purposes. And I think it's really important to emphasize that. Where people get in difficulty in terms of record keeping is if they begin to alter the client record for some purpose other than the client's needs. And so this is very simple. Does the record reflect your honest best views? You record the information that you need to provide ongoing quality care. The level of detail in the record should reflect the seriousness of the issue. The greater the risk, the more prudent it is to have detailed record keeping. The more challenges posed by the client, the more prudent it is to have detailed record keeping. Typically, the amount of information recorded will be greater at the outset as you are defining the problem or the issue of concern for the client. As you proceed with a treatment plan or a treatment contract or a counseling contract, the record keeping will probably become more focused and briefer. The record, a good record, allows someone to recreate what you heard, what you saw, what you did, and why you did it. A good counseling record provides for continuity of care in the sense that if you are removed from the scene, a subsequent social worker can come in and provide ongoing quality of care. And so basically the message in terms of record keeping is focus on the needs of the client. Now, we have seen a rise in civil liability for negligent record keeping in the last 10 to 15 years. There are two sets of concerns here. The first set is it is quite clear that the courts are demanding that institutions and organizations have record-keeping policies that ensure the confidentiality of the patient record. Now, the safeguards that are developed by an institution don't have to be perfect, but they do have to be reasonable. And so it's really critically important that agencies and practitioners understand that the standard of ensuring that patient or client information is kept confidential is higher today than what it was. I think 25 years ago, if you had patient information in your briefcase locked in your car, most courts would have said that's good enough. But with the increased prevalence of windows being smashed in cars and people stealing briefcases to get to computers and cell phones, it may not be adequate anymore. And the courts may expect that if you're carrying client or patient information in a briefcase, that the briefcase not be visible in the passenger section or locked in the trunk of your car. The second area in which we've seen increased litigation is around situations in which the record-keeping policies and practices result in clients falling between the cracks, and this is illustrated by the case of FC. This is a case in which there were two children with developmental delays who lived in group homes in the community. And they went to the same school. And they were bused to school and bused home. The young girl was less developmentally delayed than the young boy, and she convinced him to run away from school rather than getting on the bus. The group home reported the first two incidents of the children running away to the school. As soon as the school was informed of this, the school took some precautions to try to ensure that this did not occur again. The school hears nothing. The school assumes that the problem has been solved. In fact, there were two other incidents after that in which the children ran away, but the group home never informed the school. In January, the group home and Children's Aid had a meeting, and they came up with an administrative plan to prevent the kids from running away. Now, the administrative plan put all of the onus on the school. However, they never invited the school to the meeting. They never informed the school of the plan. So while it might have been a brilliant administrative plan, it was also a secret plan, and the school had no knowledge of it. The kids run away. It's Ottawa. It's January. They are gone for 4 days. The young boy suffers severe frostbite, requiring the amputation of both of his legs. A civil suit is brought against the school. The school was absolved of liability. It wasn't held liable. Why? Because when they were informed that the kids were running away, it took steps to try to avert the danger, and they reasonably assumed, because they hadn't been informed otherwise, that it was working. The group home and the Children's Aid were held liable in negligence for failing to take adequate steps to inform all of the parties to protect the children's interests. Now I'm going to turn to slide 8. Guidelines for documentation. I've set these out in the appendix, and you can review those at your leisure, but they're common sense kinds of principles that I think are wholly compatible with your professional and ethical obligations as a social worker. I now want to turn to ownership of and client access to counseling records. At common law, and that basically means unless a statute provides otherwise, at common law, if you are a sole practitioner, you own the record. You own the record. If you are employed by an institution or agency, the agency owns the client record. However, it is also clear that a patient or client has a common law right of access at common law to any information you have about them. And this is illustrated by McKinney and McDonald. And this is a 1991 case. And what happened is a woman went to her family doctor. The family doctor had sent her to various specialists. The specialists had sent back reports to the family doctor on the patient, stamped confidential. The patient approached her family doctor and wanted a copy of her file, her medical file. And the doctor said, I'll give you the reports that I produced, but I won't give you, and I can't give you, the reports from the consultants. You're going to have to go and get the consultant's consent before I can release their report to you. And the woman said no. She said, the consultants got the information from me, were treating me, it's in a file, and you are using that to make medical decisions about me. I have a legal entitlement to those records as of right. And the Supreme Court of Canada unanimously agreed in 1991. Now, the court said that if the healthcare professional can convince the court that the disclosure of the confidential of the medical record would pose a significant risk of death or grievous bodily injury, the court may choose to withhold it from the patient. So this idea that patients don't have a right of access to their entire record is simply wrong. They do, and they have it on request. And I think because of cases like McKinney, it's best to assume that the client will get access to the entire file that you have, including information from third-party confidential sources. So unless you can prove that disclosure poses a risk of death or grievous bodily injury, at common law, the patient is going to get access to that on request. It's important to distinguish between client or counseling records or treatment records, in which the patient has a common law right of access, and administrative records. An example of administrative record would be the financial records of the institution, the employment records, an incident log, any of those. Those are all administrative records. Clients have a prima facie right of access to their treatment records. They have no prima facie right of access to the administrative records. Now, the client may get access to the administrative record if he or she brings a civil suit and a court issues a subpoena. Or if the agency is a government agency, the client may have a statutory right of access, but they have no common law right. Record retention policies. It's really important to understand that the statute of limitations, now statute of limitations is a statute that says the client must bring a civil suit within a certain period of time. If the client initiates the civil suit after that period of time, the civil suit will be statute barred. In other words, it will be dismissed because of the delay. Now, at one time, the standard statute of limitations for negligence was 6 years, and a number of agencies kept their records for 7 years. But that is now, in this day and age, somewhat misleading. And that is because the court's willingness to delay the initiation of the statute of limitations. The Supreme Court of Canada, in a case called MK and MH, held that the statute of limitations for bringing a civil suit will only begin to run once the patient is aware or the client is aware of the wrong. In this case, it was a child who was sexually assaulted by her father from the age of 8. So she was probably aware that that was wrong at the age of 8. Will only begin to run once the client is aware of the harms caused by the wrong. In this case, the plaintiff didn't succeed in school, had very low self-esteem, wasn't able to establish a meaningful relationship with another male until she went into counseling at the age of 25. She thought these problems in her life, quote, were due to my own stupidity. It was only at the age of 25 that she realized that many of these problems were due to being sexually abused by her father. And the court said that the statute of limitations will only begin to run once the patient is aware of the wrong. She was aware at the age of 8. Aware of the harms caused by the wrong. She wasn't aware of that till she was 25. And psychologically able to bring suit. And she did that at the age of 28. And so the Supreme Court of Canada allowed the civil suit against the father, even though the civil suit was brought 20 years after the abuse began. Do not be lulled into a false sense of security by the statute of limitations. And I think the message is that you keep your records, particularly if you're dealing with the high-risk constituency, for a very, very long time. Computer or electronic records. There's no magic. The general rules that apply to written records apply to computer records. And again, the security system for the computer records do not have to be perfect. They only have to be reasonable. So if you have a computer program for your records, is that computer program reasonable, reasonably secure? It doesn't have to be perfectly secure. I now want to turn to the last issues that we're going to cover in the formal presentation, and that is statements of opinion. It is perfectly permissible to include in a record a statement of opinion. However, statements of opinion must be expressed as statements of opinion. So if the statement, Mrs. Smith has a drinking problem, is a statement of fact. The statement, I'm concerned that Mrs. Smith has a drinking problem, is a statement of opinion. So opinions must be stated as opinions. The factual basis upon which your opinion is based should also be recorded in the record. As long as the opinion that you express is consistent with your education, training, and work experience, there is no difficulty. Where people get in difficulty in expressing opinions is if they give, definitive medical or psychiatric diagnoses way outside of their education, training, and qualifications. Private records. There is no, at common law, ban on maintaining a private record, but it's important to understand what a private record is. A private record is a record that you create exclusively for your own use, separate and apart from the official record that is only accessible by you. So that an example of that is during your counseling sessions at your place of employment, you make jot notes. At the end of the day, you translate the jot notes into the official record, and you take your jot notes home, and you keep them in a locked filing cabinet at home, accessible only to you. That would be a private record. If the private record is kept at work, it's not going to be viewed as a private record. If the private record is available to anyone else, it's not going to be a private record. So it's a question of management policy in regard to whether or not individuals can have private records. But some things you should be aware of. First, your private records can and will be subpoenaed. The private record is not automatically admissible in court. The official record is automatically admissible in court. It's important to understand that merely because you have a private record in no way diminishes your legal obligation to have a comprehensive public record. In other words, having a private record increases. It doesn't decrease the amount of information that you have to record. And the public and private records have to be compatible. You do not want to be in court when there's fundamental discrepancies between the private record and the public record, because your integrity and honesty will be called into question. And so the public record, the private record has to be compatible. The next issue we're going to talk about is going to be, can I record information about a third party in a client file? And again, people, I think, are overly concerned about this issue. Now, let me just give you a medical analogy. I'm 68 years of age. If my doctor did not ask me questions about prostate cancer, about heart disease in my family, and record in my record that, my father died at 52 of a heart attack, or there's a history of prostate cancer, among my family, the doctor would be negligent. Any doctor that doesn't ask a woman about a history of cervical cancer or breast cancer would be negligent. So the idea that you can't record in a patient record information about a third party, I don't know where this concern arises. The issue, and there's three issues that govern, is the information about the third party, is it reasonably accurate? Is it properly attributed, and is it relevant? And it seems to me that if these same principles will apply to social workers, it's perfectly permissible in counseling an individual about their drinking problem to determine if their spouse or partner has a drinking problem, because that may well be relevant in terms of the treatment approach that is taken to address their problem. So I don't see there being any ban on recording relevant information in a patient's file about a third party. Is the information relevant? Is it reasonably accurate? And is it properly attributed? And that's quite simple. The patient reports that his father died of a heart attack at 52. It's not the doctor's opinion, it's the patient's opinion, and that's why it has to be attributed. I think the same principle applies about recording in the record information from a third party. Now, some of the health information legislation says that you should collect information directly from the client. That is true. But the legislation also permits the recording of information from a third party if the information is not readily available from the patient, him or herself, or it's not likely to be accurate. Email communication. There is no ban on email communication in any statute that I am aware of. It's a question of management policy. And I think sometimes we get overly concerned. I mean, the issue is the system for communicating by email reasonably safe? Not perfect. How many letters get sent to the wrong address? How many phone messages get sent on the wrong phone? Now, it is perfectly permissible for an agency to have a policy that administrative or mundane kinds of issues, they'll communicate by email. But highly sensitive personal information will be emailed by more secure means. The best way of addressing this issue is to ask the patient at the outset of the treatment relationship, how can I communicate with you? I think we have to accept the reality is that for the next generation, the only way you're going to be communicating is through email. And so again, agencies can have policies, but there's no prohibition in law. It's a question of management policies. Documenting clients' consents. This is an issue that has vexed a number of people and agency. The law generally does not require a signed consent form to release information. This is a matter of management policy. And the issue for the court is not did the patient drag their hand across a piece of paper. The issue for the court is did the client, understanding what information was going to be released to what person, for what purpose, agree. And so the consent to release the information can be in writing, or it can simply be given verbally and charted. Now, oftentimes, management policy requires a signed consent to release patient information. My concern with a lot of the signed consents is they're presented as a technicality. The forms are vague and general and don't communicate the kind of information that you and I would want before we agree to have our counseling information released. I'm now going to turn to slide the next slide. In my conclusion. So we've talked about what negligence is and what negligence isn't. Negligence is a failure to meet the standard of care of a reasonable social worker in all of the circumstances. We've talked about documentation, and we've talked about the fact that the law doesn't impose artificial technical rules. Rather, the law follows the profession. And if you have the record you need to provide ongoing quality care, then you have the record you need for legal purposes. Now, I'm going to, in the conclusion, give you some advice about how to avoid legal grief. Because remember, anytime you're embroiled in legal controversy, it's time-consuming, it's morale-destroying, and it's expensive. The reason you have good policies and practices in place is not to win the civil suit, but to address problems before they become issues. In other words, good record-keeping policies and practices result in providing good care to clients. So I'm going to give you some advice. First, agencies should have clear policies, and we should focus on having good communication skills. Healthcare professionals and counselors who can establish a relationship of trust with their clients can encourage and support clients to make wiser, safer, better decisions. As I always joke, counselors should be like Holiday Inns, no surprises. Everyone knows what the ground rules are, and you focus on establishing a good working relationship, a good relationship of trust with the client. Treating all clients with respect, those who deserve it and those who don't. People tend to sue other people because they feel they haven't been treated with respect, or their concerns have been ignored, or the individual is arrogant and dismissive. And when I was young, we had a family doctor, and the family doctor returned my mother's phone calls, and the family doctor made house calls. It would never have dawned on my parents to consider litigation, no matter what the decision, because that doctor was seen as being committed to our well-being and treated us with respect. And finally, keep your focus on the client. In this day and age, it is quite clear that the courts don't want to try to tell social workers how to do their job. Keep your focus on the client and the client's interest. And notice the advice I give you has nothing to do with law and everything to do about being a caring, competent social worker. Thank you very much. We're now going to turn to the question portion of the seminar.
Thank you very much, Professor Solomon. I'm going to let our audience have a look at the appendix that you have provided.
Okay.
I know I don't think it was in your plan to go into it in a great deal of detail, but we'll just let them see it.
Sure.
And know that when they access the presentation slides via the CASW website, this appendix with its guidelines for documentation will be theirs.
Okay.
First page. Do you have any comment you want to make about the page, or are we just going to have a quick look and move on?
This is guidelines for documentation. This was written with treatment or counseling records in mind. But these same general principles apply to all record keeping in terms of agencies and organizations. So it's shaped towards treatment and counseling. I guess the one point that's really, really important, or 2 points that I think that I would want to make where people tend to run amok, is the first, that some people are told they should keep their records as brief as possible in case the record is subpoenaed. Your job is not to try to anticipate what may or may not happen legally. Keep the record you need to provide ongoing quality care. Your job when you make the record is not to put the agency in the best possible light, not to tell your story, not to put the client in the best possible light. Your job is to create a record that will provide for ongoing quality care. And so if you're going to make a mistake, it's probably going to be by under-recording. The courts assume if it's not in the record, you didn't think about it. If it's not in the record, you didn't do it. Omissions in the record are interpreted negatively against the author. And so the advice that is sometimes given about keeping the record as brief as possible is bad legal advice, in my view. The second thing is that there is a tendency not to want to record in the record negative or uncomplimentary information because of the possibility that somehow it will come back to haunt the client. Again, you've got to line up your ducks. The issue is, does this record reflect your objective best view? If you begin leaving out of the record uncomplimentary or negative information, it creates the situation where the decision you make isn't supported by the record. You've got to line up your ducks. The record has to support the decisions you make. If you leave out critical information, good, bad, or indifferent, you're opening yourself up to allegations that your decision-making is arbitrary, capricious, whimsical, or worse, discriminatory. Easiest thing? Calls them as you see them to the best of your ability. Do I have the record I need to provide quality care? So those are the two points that I would emphasize, because oftentimes those are areas in which individuals have the most concern and sometimes get what I consider to be, and what most lawyers would consider to be, bad advice.
I'm going to push through to the second page because I have a question for you. In
Sure.
item number 9, I'm sorry, I just need to adjust my own slide. You use a really interesting word. You say relevant information should not be omitted simply because it's embarrassing. Can you tell me what you had in mind?
You have a drinking problem, and you're coming to me because you have a drinking problem.
Mm-hmm.
But I don't record in the record any or very little information about the drinking problem, because eventually if it goes to court and your former husband subpoenas it and in your custody battle, that won't put you in a good light.
Oh.
So that's an example. And again, I'm not your lawyer. I'm not your family lawyer. I'm your social worker. Do I need to record information about the extent and nature of your drinking problem so that I can help you? And again, keep your focus on the patient. Mm-hmm. Line up your ducks. And you know what? People come to social workers oftentimes because they have problems. And the honest and accurate assessment of the problem is critical. And so the easiest thing is to call them as you see them to the best of your ability. And I think that's the best advice that can be given to social workers. Because what I worry about is you get in a serious car crash subsequently. Right, you get in a serious car crash after you've come to me with your addiction program, and you sue me as a negligent counselor, and you subpoena the record, and there's nothing in that record, or very little in the record, about your drinking problem. And I say you claim I'm a negligent counselor because I did not address your drinking problem, and you testify under oath that you explained it to me in detail, and there's nothing in the record. So in an effort to not include embarrassing information, I've exposed myself to liability. And the easiest thing is, does this record reflect your honest best view? You don't have to be right. You only have to be reasonable. Now, one of the things that's important is that, notice I say relevant information. The more legally, emotionally, or sexually sensitive the information is, the more I'm going to want to think, is this relevant to the treatment that I'm providing? And so the legitimate way of protecting the confidentiality interests of the client is to think about, is this information relevant? And the more embarrassing, the more sensitive the information, the more I'm going to think, do I need this information? Does it have to be in the record for me to provide ongoing quality care, or someone else if I'm hit by a bus to provide ongoing quality care?
Thank you. And, I have to say that we have a lot of questions stacked up. So I'm going to thank you for this part of your presentation and move you on to some questions from our audience from across Canada.
Good.
Oh my goodness, they've really the numbers have really increased since the last time I had a look. We had a question about texting. What's our legal responsibility about messages that are texted to us, or a client wants us to text back to them because possibly that's the plan they have for their mobile phone? Where does that one fall? It's not email?
Okay. Basically, the issue is, have you taken reasonable steps in communicating the information? Okay? Now, to my way of thinking, the easiest way of solving this problem is at the outset of the relationship. Ask the client, how can I communicate with you? Can I email? Can I text? Can I fax? Can I mail? I don't want people faxing information to me at the law school because it's in a common part of the lounge. Mm-hmm. I much prefer. And so there is no hard and fast legal prohibition.
Okay.
Okay? And so it's simply a matter of management policy. Now, the other thing that you should be aware of is that you can always collect, use, and disclose information with the patient's express consent. So get the patient's express consent at the outset of the relationship to how can I communicate with you.
Okay.
And so there's nothing special. There's no magic. The question is it reasonable? Now, given my level of computer skills, I wouldn't feel comfortable, texting.
Okay.
But obviously the generation after me clearly does. I always joke that the last time my son wrote a letter, any of my children wrote a letter, it was when they were 6 and they had to write a letter home from camp before they could get into dinner. I mean, none of my kids mail a letter.
Okay.
None of them have landlines. That's the only way you're going to communicate. You should have clear policies within the agency in regard to that.
And I think another question that's just come through, and it relates to some of your comments about private practice and negligence and liability, from a practitioner who's recently closed her private practice and wonders, would it be in her best interest to maintain liability insurance coverage for the length of the statute of the limitations on the documents that she has had from her practice?
That's a very interesting question, which I've never been asked before. I tend to think that if you're going to be, and again, I'm not an expert on insurance. Your sponsors will know this. If I'm sued 10 years from now because of something I did when I was insured, I think the insurance company would still have to pay. Right?
Okay.
So if I'm in a car accident, in 2007, and they only bring suit now, I was insured in 2007. The insurance company would be on the hook in terms of liability. Now, I don't know if there'll be some post-retirement concerns around liability. They should speak to their broker.
Okay.
And just find out. It seems like the risks would be limited. Now, if I was a social worker and I had all these records and I was negligent, I retire, but I'm negligent in how I store the record, and highly confidential patient information is disclosed, I could be sued by the patient for my negligent failure to adequately safeguard. So there is a possibility, but it's small after retirement.
Okay.
So I speak to their broker.
And actually, there's a question that someone has just popped up that I wondered about myself. So these legal issues, we understand, and we may not be right here because we're not lawyers, are based on federal laws. But are there any highlighted areas that are related to provincial legislation?
Okay. All of the principles I gave you are common law principles.
Okay.
And civil liability is not controlled federally. It's controlled provincially. So the regulation of health care and counseling is a provincial matter. Now, I've given you the common law principles, and these common law principles are very similar across Canada, with the exception of Quebec, which is governed by a civil code. So right. Quebec isn't governed by common law. But the civil law principles in Quebec are very similar to the common law principles. Now, I didn't in this session deal with some of the statutory situations which are governed by statute, such as record keeping, mandatory reporting obligations.
Sure.
Because those are governed by provincial statutes, and there are differences between the child abuse reporting obligations in Ontario and the child abuse reporting obligations in Manitoba. there's a difference between the mandatory reporting obligations for unfit drivers in Quebec from those in Alberta. But healthcare generally is a provincial, not a federal matter. But the issues that we've talked about are common law, and they are very similar. They are virtually identical in every jurisdiction except Quebec, which is governed by the Civil Code. But the Civil Code principles are similar to the common law.
So based on questions of the areas you've outlined, we should refer to our provincial associations or colleges or for guidance
on the statutory side, like mandatory reporting obligations in terms of, communicable diseases and unfit drivers and child abuse and domestic violence and elder abuse. Yes.
Okay, and I have a question actually just that I'm going to direct to the audience in general. Yes, the documentation guidelines will be available through the CASW website afterward. There was a comment that they're very helpful, but we didn't have time to write them all down. So yes, they will be available. They will be able to apply them to their practice and to review them at their leisure. Lots of information about communication in records. Concerns about a client who, because of sporadic phone service and internet service due to issues of lack of funds, uses public computers as like in a public library for emailing regarding case issues, and then I suppose might be checking answers back from the social worker in the same place. Do you have any thoughts about where that would put?
Yes, clients can do anything they want. We believe in autonomy, and so clients get to make unwise decisions if they are capable. So if a patient decides to call you from a payphone in Tim Hortons and talk at the top of their lungs, you might advise them that that's probably not wise or prudent, but you're not responsible for how the client initiates the communication. Now, if they are emailing you from an address and it's clear they expect an email response, I don't think the courts are going to say, well, are you in a secure place? I don't think that's your responsibility. I think that if they email you, you can respond accordingly. So I don't think it's a question of liability on the part of the social worker. It's a question of perhaps encouraging the client or advising the client that it would be more prudent to adopt a more secure means of communication. So I don't think it's not the responsibility of the social worker.
I have a two-part question about social media, and I'll give you a whole question in case there's overlap. The first part of the question is, what about communicating with clients over social communication media if they contact you first that way, if this is their preferred method? That's one part of the question. The other one is, if I as a social worker know that my client posts information on the public part of his or her website that I as a child protection social worker would find interesting, and if I have, for instance, used that information on one occasion to protect a child or to advise a client that this particular behavior is not helpful to our progress together, am I required to continue checking that website? Is that part of my duty, my fiduciary?
Okay. I am a techno dummy, so it's hard for me to understand the context. So the first question: if someone contacts me through social media, I think that, and again, I don't understand the technology very well, other than the fact that young people today want to share the most intimate details of their life with their closest 11,000 friends, which I find really scary. It's really important that when I am contacted in my professional capacity, and I respond in my technical and my professional capacity. I would worry about using social media because it blurs the lines between my professional responsibility and personal friendship kind of stuff. So now my guess is that the colleges may well have guidelines on social media. I don't. I assume you're thinking of things like Facebook and other kinds of things.
Yes, and
yeah. Again, I would tend to shy away from it because it's blurring the lines. I'm being contacted because this person thinks I'm their friend. That this is outside of my professional responsibility. Am I being like the bartender, where I'm, the patron is discussing? There's no expectation of professionalism, no responsibility. They're just an ear. Or am I being contacted in my professional capacity as a social worker? And if I am, I have professional standards that I have to meet, et cetera. So I would be concerned about it, but I would check with the college because I'd be worried about blurring the lines. Now, the second part of the question is the mandatory reporting obligation on child abuse varies from province to province. Everyone in Ontario has a duty to report any circumstance in which they have reason to suspect that a child has or is at risk of being abused. So it wouldn't matter in what capacity. So if I was in, a grocery store and someone was beating their kid, I'm an everyone. I'd have to contact. I would have a duty to contact Children's Aid. It is only an offense in Ontario for professionals to fail to report as required. So I don't know if this individual learned of this or developed this suspicion in a professional context. If they did and failed to report, it would be a provincial offense in Ontario.
I think the question was that the open part of the website had provided information where the social worker had already acted once to protect the children. And does that mean that knowing that this is a source of information about potentially dangerous acts?
No, I assume that the individual contacted Children's Aid, or are you talking about the children protecting worker? Somebody
works for Children's Aid. Are they now required to start looking at social media?
Again, this is way beyond the level of sophistication of our courts.
Okay.
But having said that, if there was reason to believe, given what this child protection worker knew, that there was ongoing information likely relevant to the protection of the child, my tendency would be err on the side of the kid. I don't know if they'd be held liable if they didn't, review all of the junk that this person puts up. But in this day and age, you want to dot your T's and cross your I's in terms of child protection. Very heightened sensitivity. The downside risks of being overzealous with child abuse are minimal. And that's because we ignored the issue for so long. So I don't know if it'd be negligent for her to fail or him to fail to check. But if there's reason to believe that there might be relevant information, I'm going to err on the side of the kid. I'm going to tend to make decisions which make it easier for me to sleep at night.
Thank you, because the Facebook issue has come up a number of times. People saying, if it's public, I feel comfortable accessing it, and then there's the issue of can I friend somebody, and then further into their information.
I think you can friend somebody outside of your professional relationship. You can't. I think it's a real problem because the lines become blurred and the expectations become blurred, and you lose your objectivity. Where social workers get sued or have been sued in the family law area is when they decide their job is to get mom the kid, to get mom custody of the kid.
Okay.
They lose their objectivity.
Yeah.
They frame it in terms of mom's interest. I'm sorry. Mom's not the client. The client is the kid. And the Supreme Court of Canada has made it clear. When you're seeing a child, you owe a duty of care to the child. Not the parent who brings them in, not the parent who pays them. And so what I worry about is when people, friend other people or friend clients, that the lines get blurred, and I think it poses significant difficulties. There is a body of literature on professionalism and boundaries and boundary violations. And in this day and age, I think it's really important that we maintain those boundaries. I think it's cleaner and fairer to the client and cleaner and fairer to the social worker. It may be difficult for me both to be your addictions counselor and your friend, because I might have to tell you things you don't want to hear.
And with that, I'm afraid we're finished our time for questions. And I have to tell you, there were lots of questions, and there were comments that for the first time in a number of years of following our webinars, this was this person's first time with a webinar that dealt with these issues. So I want to thank everyone who joined us today. I do apologize. I know we couldn't get to everyone's questions due to time constraints. I want to thank Professor Solomon for lending his time and his experience to this, and for your ongoing contributions in support of our profession. I thank everyone again, and I hope you all enjoy the last week of Social Work Month. I'm just struggling a little bit with my slides here myself. Well, maybe the last, oh, there it goes. Okay, and again, Dr. Solomon, thank you very much. I also want to thank our insurance provider, Aon, our national liability insurance provider, for sponsoring this presentation, very apropos with Professor Solomon and Aon. Thank you for attending. Please let your colleagues know that the website presentation will be linked to the CASW website for the next year. Look for the link in April's CASW monthly e-newsletter, The Reporter. Thank you again, everyone, for coming today. We had a great turnout and a very interesting presentation and conversation with Professor Solomon. Thank you, everyone, and goodbye.
Goodbye.